Looks as though we're getting started. Good afternoon or good morning, depending upon your geographic area. I'd like to welcome everyone to our second in a series of roundtables to discuss the impacts of the recent executive orders on the construction industry. My name is Frank Junta. I'm a partner with HKA, and I will be the moderator for today's discussions. For those of you who tuned in, our last webinar was on October 15th, and it spoke about the impact that tariffs were having on construction. Today's discussion is going to focus on labor and immigration impacts to the construction industry. Currently, the construction industry faces delays and an inability to meet schedules due to labor shortages. Uncertainty in labor availability is creating cost uncertainty. Shortages of less expensive labor options is driving up labor costs. The goal of this roundtable is to discuss what is happening, how construction labor is impacted, how immigration laws are impacting other aspects of delivery, and potential solutions for navigating this environment. With us today to explore this topic are three preeminent experts in the field. First, Michael Nefak, Managing Principal at Jackson Lewis and one of the top 5 immigration lawyers. Next, we have Patrick Shen, who serves as the Vice President for Immigration Policy at the U.S. Chamber of Commerce. And last, but certainly not least, is Shelby Skibek, Senior Legal Counsel at Gilbane. Before we meet our panel, I'd just like to remind everyone that our discussion today will not address political aspects of the current regulations, but rather how construction is being impacted by these very regulations. Also, if you have any questions, you can ask them through the chat box. My partner in crime today, John Palin, and my partner at HKA will be monitoring those questions and interrupting us as appropriate to bring them to the forefront. So please do not hesitate to ask questions. If there are some things during this discussion that didn't get covered and you'd like to hear about, please drop us a line because this is an ongoing series, as you'll hear towards the end. But now let's get into it and let's meet our panel. First, Michael, can you give us a brief introduction?
Sure. Thank you, Frank, and I'm thrilled to be here. I don't know if I'm about one of the top 5 attorneys, but I feel like I'm one of the top oldest attorneys here. I have been doing immigration for over 30 years. I've been with Jackson Lewis in the DC region office since 2010. Before that, I was in the government for years. My last position there was the general counsel at ICE. And this has certainly been a critical and important topic for employers for longer than just this administration, but the last year has really been something.
Thank you, Michael. Next up, Patrick.
Yeah, hey folks, thanks for having me here. I feel it's a privilege for me to be part of an ABA event because as of 6 months ago, I'm not a lawyer anymore. I did practice in the immigration space in government and in private practice for over 30 years before joining the Chamber of Commerce. I've known Michael Nefak for, oh gosh, if we start talking about how long, then we're both really old. Yeah, but we both last worked for the government during George W. Bush's second term. So I'm now with the Chamber of Commerce. We represent basically everybody, including the construction trade. And I know that we're going to go into the big policy picture on immigration in a little bit, but just I want to leave with this caveat that it is now 1:04 p.m. Eastern time. By the time we're done around 2 p.m., if anything new comes up and I don't get a chance to cover it, I'm happy to follow up.
Thank you, Patrick. And Shelby?
Hello, thank you, everyone. I'm Shelby Skibek. I'm in-house counsel at Gilbane Building Company. We're a major construction manager located all throughout the United States. I've been with Gilbane since 2022. I've been a labor and employment attorney since 2012. And along with doing labor and employment, ethics and compliance is a lot of what I deal with on a day-to-day basis. I'm not a construction attorney, but because I'm in the construction field, I see a lot of the bleed over and what kind of happens. And so I'm really excited to be here to give the in-house counsel perspective.
Thank you, Shelby. So let's get started. Let's kick it off at a broad summary level. And Patrick, if you would be so kind as to kick us off and sort of give us an overview from a policy perspective.
Sure. And I will focus on the impact on workforce which I think would be, probably the top interest of our audience today. This is not to say that other policy considerations, the humanitarian aspect, they're important to us on a personal level, of course, right? But for the time that we have, I want to focus on workforce. Okay, so at all skill levels, immigration has been impacted. So let me start with something that's been in the news, and that it'll impact many of our listeners here today. If you're with a company, it's probably going to have an impact at your corporate office level, right? If you need construction engineers or IT people. Since September 21st of this year, there was a executive proclamation. It didn't go through rulemaking, but an executive proclamation imposing a $100,000 fee on each H-1B visa. Okay, and of course that creates quite a concern for our members and for companies across different sectors. The idea of an H-1B visa, if used correctly, right, is to bring foreign talent with specialized knowledge, highly educated, to complement the U.S. workforce, not to replace the U.S. workforce. So if you don't have the people you need, right, you either cannot produce or you have to produce somewhere outside of the United States, and neither one is a good option. We are seeing limited, another proposal. This one is still a proposed rule that will limit the duration that students and exchange visitors can stay, and that, of course, impacts the pipeline of talent. There is also another proposed rule that changes how the H-1B visa is allocated, because the demand always exceeds the supply of quotas. There has to be a lottery, and the rule will make it really difficult for new professionals, new graduates, right, to enter the U.S. workforce because of the way the lottery is weighted and heavily in favor of more senior people. Since the beginning of the year, and some of our listeners are your clients, or maybe you're either in-house or if you're with a firm, your outside corporate construction company clients would have felt this, because since about, I'd say, February, March of this year, we're seeing the elimination of several categories of humanitarian programs that offers work authorization. So when those programs ended, and often abruptly, the work authorization ended as well. So first, the many industries, whether it's construction or agriculture, right, hospitality, lost estimates vary, but I think it's fair to say it's upwards of 1 million legal workers who suddenly became illegal. So what the employers felt then was losing collectively over 1 million legal workers when you're short on workers already. And secondly, because of the way it was done abruptly, employers did not always know, and until today may not always know, who among your workers just lost work authorization. And that creates a legal liability in addition to a financial liability. Right? On top of that, very recently, on October 30th, the Department of Homeland Security eliminated now this one is not a proposed rule. This one is a interim final rule. So it's effective immediately that the existing auto extension for work authorization, those are those who do not have visas, don't have permanent U.S. worker status, but who are here legally and are granted the authorization to work. That auto extension of 540 days between adjudications taken away, which wouldn't be a problem if the government can adjudicate, applications quickly. But often we see a gap of many, many months. I've seen one 13 months is the longest I've seen personally. And that's going to create a gap in work authorization. It's going to create a problem for these individuals who cannot make a living, even though they're in the country legally with permission from the United States government. And of course, to our listeners and your clients, right? What are they supposed to do when somebody who is productive suddenly can't work and you don't know when they're coming back? So these are the issues that are facing us today. And I'm going to stop there and let my friend and colleague, Michael, talk more about the law.
Thank you, Patrick. So Michael, with that lead in, your perspective from the legal side?
Yeah, I think, and Patrick hit on a number of some of these similar overlapping points. But look, it was no surprise that the Trump administration and President-elect Trump was making immigration was front and center, and it was really from a compliance standpoint. And right at the inauguration of January 20th, President Trump signed 12 immigration-related executive orders and rescinded 5 Biden-era executive orders. And really, they were rescinding those orders that were facilitating and making it easier for people to come here, for people to get work authorization, regardless of how they came here and whether they came over the southern border and might have been paroled or allowed in temporarily. They were given the ability to get work authorization. That was all ended on day one. And we saw with these executive orders, not only focused on the border and tightening up the border, which the administration really has done, but also looking at individuals who are getting visas abroad and really enhancing vetting of individuals who are applying for visas. We've seen scrutiny of people's social media accounts to see whether they may or may not, have done anything that would be viewed as against the interests of the U.S. And really, it's become much more difficult and taken a longer time for individuals, certain individuals, to get a visa and be able to travel here. And that includes, high-level executives, companies that have affiliates overseas and are used to being able to have frequent travelers back and forth. Some of those folks are having a harder time getting a new visa, or they're finding that their existing visas have been revoked. As Patrick mentioned, rescission of humanitarian parole and TPS. This is estimated, 1 million plus, 1.5 million or more individuals who, during the Biden administration, were able to come to the United States, or if they were already here under what's called temporary protective status, and these were Haitians, Venezuelans, Nicaraguans, El Salvadorans. There were populations where these individuals couldn't return back to their home countries for various reasons, and they're given temporary protective status, which in some instances has been going on for 15 or more years. Those people were work authorized, and the Trump administration said we're going to end those programs and terminate employment authorizations for those individuals. A lot of this has been in litigation that's ongoing, but in most instances, the Supreme Court has made it very clear that the administration, while that litigation is pending, can revoke those work authorizations, and employers now are having to make difficult decisions on terminating employees, making up for those gaps in their workforce, and it's been a real challenge. We've also seen there were executive orders on enhanced interior immigration enforcement, and that's really the worksite enforcement. And we've seen there's been a number of high-profile enforcement actions. The Hyundai plant, there have been dairy farms in the Midwest. There have been a number of high-profile enforcement actions where ICE and other law enforcement has been going in, requesting, some instances they start with a request to see your I-9 audits or your I-9 forms, but in other ones, they'll come in with judicial warrants and really close down a plant, start to talk to the employees and segregate those individuals who don't have work authorization and put those people in removal proceedings. It's had a huge impact on employers in a number of industries, including the construction industry. So, with those increased ICE worksite enforcement actions, we're seeing not only civil fines and penalties just for I-9 violations, and for a simple I-9 violation where there's what's called a substantive violation, you can get a fine for up to $2,861 per I-9. So if you're talking hundreds of employees and you don't have your I-9s done correctly, that quickly adds up, and we're seeing those. We're also seeing where there may not be I-9s, or it's very apparent that individuals may have been hired with fake documents or what have you. There's the potential for knowing hire violations, knowing or continuing to employ unauthorized individuals. Those can be civil. at a higher civil fine level, but they can also, in a given circumstance, bleed into potential criminal charges. Where there's violations and you've got federal contracts, employers that have federal contracts and are found to have knowingly hired or continue to employ unauthorized aliens, that can lead to debarment. So even if you don't have any I-9 violations, if there's a debarment, that can be the death knell to companies. And then, employee terminations, even where there are no I-9 violations, if there are unauthorized workers, ICE is not going to allow that to continue. They've been really cracking down, and the time period that ICE is allowing for employers to continue operating while they go through documents, et cetera, has really been narrowed to it's no more than 10 days. And employers now are going to find that they're going to have to start terminating employees within a very short period of time, which leads to disruptions, not to mention public relation nightmares. So it's really been an eye-opening past several months. I think it's going to continue on for the next several months, and certainly through the midterm elections. So it's something that all employers really need to focus on.
Thank you, Michael, and thank you, Patrick. Clearly, there's a lot going on, a lot to process. And so, Shelby, how have the recent changes in immigration policy been impacting your construction projects and your ability to go forward?
I think my co-panelists did an excellent job of table setting here and setting this up and showing just how nuanced and dense this could be. And what I always like to remember, and I'm a labor and employment attorney at heart, I didn't think I'd be working in the construction industry, but construction is really a people business. You can't build without people. And it's clear that this is having a huge impact on the workforce. The AGC does an annual survey where they measure the state of the industry's labor market. And just this year, in August, they found, of all the AGC members that participated in the survey, that nearly a third of the firms have been impacted because of project delays related to the construction workforce shortage. That's huge. That should tell you exactly how much this is really affecting this industry and this group of employers. Now, if you're interested, I would encourage you to go to the AGC's website, take a look at the data. It's really interesting. You can slice it and dice it a bunch of different ways by geography, union, open shop, non-open shop, and then by industry. But I think what really I've seen and I've been really closely paying attention to are examples of where we see, as Michael and Patrick identified, ICE really stepping up their enforcement mechanisms or their enforcement in construction. Michael mentioned the Hyundai EV battery plant in, I think it was Georgia. They detained over 400 workers, most of them being South Korean workers. And a lot of this turned into a big political issue because a lot of them were detained and then turned back to South Korea. I mean, that was a $7.6 billion plant that was essentially shut down because of this huge enforcement action. The DHS itself has said, as of September 23rd in its own press release, they believe that 2 million illegal aliens have been removed or self-deported since January 20th. That's 1.6 million people self-deported and 400,000 deportations. And I also take a really close look and I'm monitoring the news to figure out what other type of construction sites are really being targeted. In May of this year, DHS targeted a student housing development down in Florida. So while you think maybe they're just going to be focusing on smaller contractors or smaller construction sites, the Hyundai and Florida State examples show that this is a much bigger issue and it's impacting all of my business people, and they're really concerned about it. And they're coming and asking me and the other attorneys that support them, what do we do? How do we handle this?
Thank you, Shelby. So let's get specific.
Yeah.
ICE shows up at the front gate. What do you tell your people? What do you do?
Yeah, this is I've gotten this call a few times. First, I say, hey, do you have the ICE guidance that we issued back in January. Because as Michael was saying, this was very clear from the beginning that this was on President Trump's agenda. So when he was elected back in November, we quickly put together an ICE raid guidance document. It's a protocol that has do's and don'ts for our field workers on what to do if ICE shows up. So we issued that immediately in January, as soon as President Trump was sworn in. And so I've actually done trainings throughout the country for our field workers and for our job sites on what to do based on this guidance. And ideally, what would be the perfect world is ICE shows up and maybe there's a couple of them and they've got their warrant, either a judicial or administrative warrant, depending on what they can search. And they present it to the most senior leader on site. And that senior leader says, okay, thank you. Can you please come sit in this room where there's no documents and no people while I call my counsel so we can look at this warrant and figure out what we're going to do. That is what we hope would happen. But I think it is very clear that that is not likely the scenario. And especially with this administration being very focused on highlighting a lot of their enforcement actions in social media, there is a huge scrutiny on all of the interactions that our employees as the construction manager will have with these ICE agents. And, the concern is that they'll come in, they'll be windbreakered up, they might have some kind of weapons, and they're going to come in full force and they're going to want to execute on those warrants. And our main statement to our work sites since this has been going on is you need to maintain safety first. Safety is critical. We all know as construction attorneys, construction is dangerous. And while we would love to be able to have control over the access to the site, specifically if there's high work going on or dangerous work going on, that may not be the case. So what we've told our project teams is make sure you've got someone very senior in place that can go and talk to the ICE agent and find out as much information as they can. This is going to probably be a very scary thing for people. So we've really taken an empathetic view towards this and said, make sure that you are making sure that people are safe. We also put together these do's and don'ts. The do's and don'ts are pretty simple, but it's mostly about making sure safety and that we are making sure we have a safe workplace and that the people that are interfacing with any of the ICE agents remain calm, courteous, cooperative, professional. We obviously don't want them obstructing any kind of proceedings or executions of the warrant. We advise them don't delete or shred or conceal any documentation. Don't try to hide any employees that you think might be the subject of the ICE enforcement. Don't provide false or misleading information. And this may seem to all of us like obvious, but in the heat of a moment, this guidance that we put together is what we're hoping will maintain some sort of safety at the work site and allow individuals to have some relief when this is going on, because it's going to be a highly emotional experience. And I'm sure Michael or Patrick, you might have some really good thoughts on that.
No, I think Shelby, you hit on a couple of really good points. First is be prepared. Don't wait, because especially if ICE comes with a judicial warrant, they're not going to wait for your person at the front to contact the most senior person there to then get in touch with an attorney and to find out what we can do. If they've got a judicial warrant, really it's get a copy of the warrant, get it to an attorney as fast as you can, have somebody who can sort of monitor overall what's going on there. And then it's going to be a lot of after action. What happened, who did they talk to, all of that. But there's not going to be any time. So the key is to have those plans well in advance of anything. Prepare now. The other thing to remember is that most of these ICE visits are not going to be with a judicial warrant. Those judicial warrants, those are not easy to get. They're very time consuming. ICE has to build a case, present that to a U.S. attorney, the whole thing. I mean, it has to go to a judge, et cetera, et cetera. Those are not easy to get. But ICE will often stop by, will often visit, will often do an I-9 audit. And a lot of that can be used to potentially build a case where there's a federal warrant. The best way that ICE can find out about, who are the employees there is to knock on your door, hand you what's called a notice of inspection, say, show us all of your I-9s, and then also give an administrative subpoena with that, saying we'd also like payroll records, tax information, et cetera, et cetera. Now is the time to make sure that your folks there understand what the rules are. They have 3 days to provide those I-9s. ICE will, of course, ask, will you let us come in and we'll talk about it right now, but you don't have to do that absent a warrant. It's important for your folks at the front, to know what the do's and don'ts are, to be familiar with what is a judicial warrant versus an administrative one. Also, in construction, often where the job site, it's not an office with a, public area, private area. It's often it may be open, it may be closed. There may be a general contractor, subs, that everybody's sort of intermingling.
Yeah.
And there are do's and don'ts there of what if ICE shows up? Should I invite them in? Am I authorized to invite them in? What if they come to my trailer that's on site and it is my property? Those are the sorts of things that you really need to think through now and make sure that you've got people that have the wits about them and are going to be on site and can deal with an ICE officer in those circumstances.
I think that's an excellent point you just raised. You're talking about getting prepped ahead of time. And what we've really encouraged our job site people to do is go talk to the owner, go talk to the subs, go talk to your JV partner, say, hey, we've gotten something from our legal department with some guidance on how to handle if this happens, but what are you planning? How do we collaborate together? And that collaboration is really going to help when it comes down to the very time sensitive, emotionally sensitive and charged enforcement action. And one more thing I just wanted to add is, it's interesting what I've seen is that a lot of times I've heard reports of ICE being around our job sites, but not actually like coming, or they don't stand close enough to the turnstile or to the entrance, but they're there and maybe they're stopping some people and asking them some questions, or down the road there's a checkpoint and they stopped a car and they've asked some questions. So to your point, that they are starting to collect this information for maybe the purposes is for a judicial warrant, I don't know, or maybe they're just trying to do other types of enforcement actions, but we've seen that.
Yeah, no, that's exactly right. And, I get a lot of calls with, hey, there was an ICE raid at so-and-so, especially early in the first few months of the administration. We were hearing all sorts of reports of ICE raids, which really were not ICE raids. ICE was going on public areas. They might be at a gas station across the street from a location, or they might be at in a parking lot, an open parking lot, waiting to see who was coming in. And that's not an ICE raid. ICE is they can be in a public area and then potentially question individuals and they have to have cause or what have you, but that's a different analysis of whether, they're coming onto private property and effectuating a warrant. So keep that in mind. I've seen in the construction industry, I get calls regularly about, hey, we just saw a number of unmarked black vans that were outside and now everybody is running. And it's just, you're going to have to deal with situations like that. And some of that is, making sure that your employees know that you got their back, and that, there is a process that you've got so that if ICE were to come onto the location, you'll deal with this in a legal and way that, has their back, so that folks aren't just living in fear constantly, when really a lot of the news reports may be beyond what, it's not an ICE raid.
Shelby and Michael, great information. Thank you for that. Shelby, you mentioned other parties such as subcontractors. Gilbane's a very sophisticated contractor, but what do you do about your subcontractors? What do you tell them? How do you make sure that they're getting the message about what to do? Because they can impact the project just as much as your main people.
Yeah, absolutely. I mean, we obviously have very robust trade contractor agreements with our trade contractors, with our subs. In there, we have a compliance with all law requirement, including we call out immigration laws. And we make it very clear that we expect they comply with the law and make sure that they understand their obligations. So to your point, sometimes we've got some newer contractors that are new and up and coming, maybe not as sophisticated. We do all we can to help them understand their obligations and what our expectations are of them as the construction manager, meaning they're hiring people that are authorized to work and they're keeping their staff up and coming and being able to provide the services that are required under the trade contract, because otherwise then you have a potential schedule issue.
You know, that's also with the subcontractors, it's an important consideration from an immigration standpoint, because I often get the call, hey, you know, can I just avoid all of these I-9 obligation and knowing higher potential violations by just subbing this all out? I can't, if I've got a subcontractor, they're their employees, I'm not responsible for anything, and I sort of wash my hands of this. I've seen this also in situations where, hey, ICE showed up, we got an I-9 on it, we had to terminate a bunch of people. I'm just going to have those people work now for a sub and come back in. Under the law, you know, while you can't I-9 and verify the employment of a contract employee, you also can't avoid responsibility if you know that those subcontractors or those contract employees are illegal. That in those circumstances, the I-9 rules apply to you, and you can be in violation of a knowing hire, even if it is a sub, if you know about that. So don't think you can just wash your hands of it. So Shelby, you're making sure that your contract terms include obligations of the subs. If you're in an E-Verify state and you have to use E-Verify under the federal contract, or you're a federal contractor and you have to use E-Verify, there's flow down provisions there, and you're going to have to make sure that your subs are also using E-Verify under the federal contracting rules. So you do need to make sure that you're dealing with your subs and your contract employees carefully.
Thank you, Michael. Let's bring it up a little bit and come back to our policy guru, Patrick, and how do retroactive changes to the worker authorization affect both employers and employees?
Yeah, so that's actually both a policy and a legal dilemma, right? The obvious policy issue is, you know, do we have enough workers in the United States? You know, and I respect the fact that there are different views on that, but I think the clients of those represented on this call would know best because they're experiencing it, right, firsthand. You know, to them it's not a, you know, just a concept. You know, it's their reality. Do they have enough people working for them? I suspect that with all the efforts in DC, all the resources these companies collectively put into lobbying, they're not here wasting their time to solve a problem that doesn't exist. That's my guess, right? And so of course, you know, when there is already a shortage in both a labor shortage and a skill shortage and I hear often from the construction trade, right, removing more employees from the legal worker pool is a problem. But and this is something that Michael alluded to earlier, which is the idea of constructive knowledge, right? You don't have to really know. I just to say that you should have known, right? And that creates a real exposure, which I'll let my lawyer co-panelists here address in greater detail. But you know, if you don't know who on your workforce just lost their work authorization because of a change in government regulation, and the government doesn't give you the tools, and then ICE shows up and said, "How could you not know?" Right? Just the fact that you have to explain yourself is going to be more resources spent on that as opposed to doing something that these construction companies are meant to do, which is to build homes and buildings for the American people. So, so I think that's something I think, you know, maybe we should segue to Shelby and Michael to discuss sort of, you know, how does constructive knowledge expose construction companies?
Look, this is a huge challenge, and it's sort of been a cat and mouse game with the government. You know, you've got for all of the compliance related requirements on the from ICE's perspective, there are anti-discrimination provisions out there that you can't. You really can only go so far, or should go so far, if you've got somebody who provides you with a work authorization document, or, you know, some I-9 related document that appears to be genuine and belong to the person. That really is the end of it. But then, you know, as you mentioned, Patrick, where you've got 1.5 million or so individuals who may have a work authorization document that now the government has revoked, What are the obligations and where does an employer have knowledge or constructive knowledge that they may be employing somebody who's unauthorized? And the government has started, realizes that. And for those who use E-Verify, there have been additional procedures put in place so that now there are revocation notices that are being sent through E-Verify saying that this individual with a parole-based work authorization that is still has time on it on its face, that's been revoked. And now the employer is on notice that, in fact, I've got to follow up, notwithstanding that the document looks good, and question that person, re-verify them, and if they don't have some other document, which they may have, terminate them. It's just added layers and layers, and if you don't follow those layers that are time consuming, there's uncertainty. It's not crystal clear, even for an attorney who's been doing this for years. These raise very interesting questions, but if you get it wrong as an employer, you might be on the hook if ICE shows up, and it's just that's why it's just so important to make sure that you keep educated on this. You're following what's out there and what the government is providing, and where you're just not sure, you're following up within your own counsel, and then if you need outside counsel to get a read on it.
Yeah, I get this
Frank,
question probably once a week now, if not more, where HR is coming to me and saying, well, we've got this employment authorization document, or we've got this TPS document, and we can't really tell if this person is able to work or not. And it requires a lot of time by me or others, or we go to outside counsel and say, what's the latest? What does this look like? And this is requiring a lot of intense scrutiny for our HR people. And we've really had to train them to be able to spot this and understand that what you might have assumed was acceptable before, or there was a extension before, that's no longer. So we have to really stop and create this kind of mechanism to review thoroughly. So training is key there.
And
So
this
Michael,
is what
you
really
alluded-
happened. Oh,
I'm sorry, Patrick, go right ahead. I was just going to say, Michael alluded to employer may be on the hook. Specifically, what are the risks, Michael or Patrick, to an employer if they unknowingly hire an unauthorized worker?
Well, it's the anything from the accusation of constructive knowledge to losing. So there could be possible, immigration fines. The possibility of losing a government contract because of debarment. Right. That, by the way, that's not new. That's from a President Clinton executive order. So it's been around a long time. But what I've seen this debarment tool being used, and by the way, again, not just during the Trump administration. I'll be really clear. The immigration issue has, we've needed immigration reform and fixes for a long time, long before President Trump's second term or first term. It's just that we're, because of heightened enforcement, it's become more imminent than ever that we have to take do something about reforming our immigration. So back when I was a lawyer, I remember there were cases where the employer, missed a re-verification, right? There was a small gap. We're talking about like a week, okay, of long-time employees. They were legal. There was a gap, and then they said, "Oh, we should have re-verified." A week later, they re-verified, right? I've actually seen ICE using that gap as a reason to drag this employer before the federal debarment proceedings, so they wouldn't be eligible for a federal contract. I mean, so that, that's a lot more, as expensive as Michael said the I-9 fines are, that is a lot more costly. But over what, right? Not that we shouldn't take form seriously, but, if you consider why the I-9 form is there at all, it's kind of silly, right? The I-9 form is there because employers, back in 1986, as a compromise to the amnesty that President Reagan signed, employers are asked to be partners of law enforcement to help verify identity and work authorization. So for the last 37 years, 39 years, we have seen employers treated like suspects, right? you forgot to check a box on that form. Oh, well, that's a $2,000 fine, right? Oh, you were 2 days late on this form, even though you've done everything to ensure you're hiring someone who's legal, right? There's a penalty right there, right? So are employers suspects or partners? I mean, good lawyers like Shelby and Michael, they'll take it either way. They can protect their clients either way. But I think we as a country needs to be clearer in how we view this relationship.
Yeah, I do agree that there's a level of frustration with the I-9 form because it's now it's back to a one-page form, but there's a guideline that the government issues. It's called the M274, which is sort of the Bible for how to complete your I-9, which is I think up to 90 something pages. And there's a lot of it's viewed as it can be low-hanging fruit. It's an easy way to find violations and rack up fines and show you're enforcing the law, but it's not getting to anything really. This administration, I see, I'm not saying that that's not the case, and you've got to make sure your I-9s are done, timely, and I will see even with employers that use an electronic I-9 system that's more dummy proof and the form itself should be done right. If from an onboarding standpoint, you're completing the I-9 section 1 is being done 1 day late, and that's the way it's done, every one of those forms is a substantive violation, and you will just rack up, those $2,000 to $2,800 fine over and over, and you can do the math. But I think this administration is really also looking at it as a tool, an investigations tool, to get a look at the workforce and to see if there are unauthorized workers there, and really then potentially, leading to a full-on raid, or just those sort of picking people off at the work site and in that area outside in public areas, which is going to have a huge impact on your daily operations. And certainly if you get an I-9 audit and you get what's then a notice of suspect documents, which is where the government looks at all the I-9s and says, hey, you might have done your I-9 right, but we know that these documents are fake or don't belong to that person. You've got 10 days now to call that person back in, see if they've got alternative documents, or maybe there's a mistake. You can contest it. Most of the time, though, once that notification gets out there, those employees aren't going to show up to work again. Again, at the end of the day, whether you get a fine or not, it's going to have a huge impact on your ability to conduct operations.
And I'd like to piggyback on that. I mean, the operations piece is so critical. I mean, obviously, we need to build the building within the schedule so that we can make sure that we're doing things timely and efficiently. But think about the impact on people. Like, think about if this kind of detainment happens right outside of the job site, but people see this. That's going to have a huge ripple effect for those individuals, those humans who are observing that when they come to work the next day. And, I think we all know that construction is one of the biggest industries where people have mental health issues. And this is probably going to be a huge impact for them. And so maybe, piggybacking on another thing Michael said is, the way to try and get away from these kind of technical violations or these issues in the I-9 is do audits. I tell my HR people all the time, we need to be doing spot checks of our I-9s on a regular basis to be figuring out, are we completing them correctly? Do our people understand how to complete them? Is there confusion? Because if that's the case, we can maybe catch something before any other compliance or enforcement issues come up.
Such a good point, Shelby, because, even though you can't necessarily, if you've done your I-9 late, there's nothing you can do to correct that. It's a substantive violation. But if you go back and you do an internal audit and you've identified that, and you've, where you do need to re-verify somebody and it's late, and you do it and you make it very clear that, per an internal review, we on our own flagged this and identified it, corrected as best we can, then you can get some remediation, some credit or what have you from the government, or if you want to take it to an administrative law judge, whatever. But if you waited until ICE shows up and knocks up on the door, it's very clear you don't get credit for that. And you really can't make those corrections after ICE has showed up. So those internal audits are important from that aspect. And then also going forward, even if you've got problems in the past, put in place a process so that you're minimizing that risk going forward.
Thank you, Michael. So to this point, we spent a lot of time speaking about authorized workers, how to make sure they're authorized, some of the penalties. A big player in that is obviously the H-1B visa. Patrick, you alluded to the H-1B visa in your opening statement. Can you talk a little bit more about the H-1B visa and how they're evolving?
Sure. Well, the H-1B visa is the most common tool available to employers to retain talent in the United States. Right? It is a bridge from students who are studying in our country to possibly retaining them here permanently. Right? So it's a employment-based temporary visa for people with specialized knowledge. That usually means at least a college degree, and typically employees can get it. Each employee can get it, with renewals and everything, up to about 6 years. At which time the employer and employee can decide if this person, the employer wants to sponsor the person for a green card, wants to stay, or this person wants to move on. We live in a global economy where people move around. The days of highly educated people from other countries moving here and want to stay here at all costs. I don't think we live in that economy anymore. Other countries are vying for talent as well. So that's the use of the H-1B visa. Over time, except for a brief period in the early part of the century, where there was a temporary spike of the H-1B visa quota up to as high as 195,000. After 2004, that baseline quota has been reduced to the statutory 65,000, and around 2005, there was the creation of another 20,000 for employees with a advanced, a master's or higher degree awarded by a U.S. university. Right? The demand, however, is at least 3 to 4 times that every year. So for that reason, the Immigration Service Agency, USCIS, runs a lottery every year to determine who can get one of the allotted numbers. And that's been the way it's always done. We certainly feel that something as important as retaining talent and keeping America innovative and productive and competitive in today's economy should not be left to a game of chance. But that's what we have. What the new proposed regulation would do, this is in addition to the $100,000 fee, right, is that it would change the way the lotteries run, so that the more senior position you're filling, the higher you are in the Labor Department wage rate, the better chance you have of being selected, right? Now that sounds okay, except a lot of the H-1Bs are used not to move senior people from outside the country, but to recruit on campus. And this new weighted lottery rule would make it extremely difficult, if not impossible, to hire new graduates from U.S. universities. These are foreign students that have been trained by U.S. universities that want to stay here and contribute to our economy, to our innovation. And so that's why the employer community has concerns, not only with the $100,000 fee, which is obvious, but also with the way that the lottery is being proposed to run starting this upcoming fiscal year.
And Shelby, from an operational standpoint, I know our company, for instance, was a very big supporter of the H-1B program, and we've struggled of late trying to figure a course through it. How's it affecting your ability with regard to recruiting talent and running operations?
As a construction manager, we do have a lot of these college hires that would fall into this category of the H-1B program. When this first came out, we were very aware of it and looking at it and closely scrutinizing it. I think optically it seemed like it was going to be a really big hurdle for us, especially when going to college fairs for career fairs. But I talked to our recruitment person this morning, actually, just to kind of get a sense, and her evaluation thus far is it hasn't really impacted us because it's such a small population of our applications that we get in that would qualify under this H-1B kind of designation. But it certainly has had some impacts to those students that are subject to it, and it's caused a lot of angst for them, understandably. And I think we are really in this kind of sit and watch period right now to see what happens and what continues and what goes forward. I don't know. I mean, you could ask me this question in 2 months and my answer might completely change just because that's kind of how things have been going.
Thanks, Shelby. Michael, from a legal perspective, what are the implications for companies that can no longer sponsor the H-1B? What are their alternatives? Where do you see it going?
Yeah, I mean, it's a real challenge, and I think, Patrick mentioning the new wage rules that may be in place are going to have a huge impact on the ability of students to get these H-1Bs. Options out there are training programs. There's J1s. Is that potentially an option? It really becomes an issue of for some international companies, they can park people abroad for a year and potentially use an intra-company transfer. But if you're a construction industry and you've got individuals that H-1Bs that you want to have working on IT or, your whatever programs or back office things, it's just going to be it's going to be difficult to have foreign expertise that's in the US unless they've got some other existing visas. Maybe, if they've got an H-1B already and you can transfer it while they're in the United States, then that may be something that's feasible. So I think it's going to make those people who already have H-1Bs much more valuable. That's always been a really valuable place to be, and it's been frustrating for employers who may have sponsored those H-1Bs and then find that those employees now are hopping to another company. And it's sort of, it's going to be interesting to see how companies vie for that limited pool of talent. But there's not a great substitute that's out there for H-1Bs.
That's right.
Patrick, before we leave the H-1B subject, it has been something with a lot of fluctuation. You mentioned the $100,000 fee. It is going to be applied. It isn't going to be applied. Where do you see the policy ending up on this?
On the $100,000 fee?
On the H-1B visa program in general, where do you see it ending up?
Well, I mean, it is in a state of flux, right? And I think I can mention this because it's public. The Chamber of Commerce filed a lawsuit against the government on the $100,000 fee. So, we obviously hope we win and that the requirement goes away, but we'll have to see. We filed comments to the weighted lottery rule, right, expressing all the concerns that Shelby and Michael just mentioned. But I think, what we really need to help our elected officials and, anyone from elected officials to think tanks to understand, those who have been critical of the program, is that, when Shelby's company or anyone else represented, by those on this call, when they go on campuses to recruit, it's very unusual, I would say impossible, for them to say to the career services people on campus, say, hey, show me your foreigners, right? That's just not what employers say, right? What they say is, hey, I want to talk to, I don't know, the top 25% of your class, right? Or whoever, we're talking to whoever's interested, qualified students. It's just that in certain fields, whether it's STEM, engineering, right, or a lot of fields that includes those who work in the construction trade, are going to be foreign students, right? So the thought that they meaning the employer community is using the H-1B to find cheap workers. Now, are they cheap workers? Well, not if they follow the rules, and most employers do. And if there are those who are cheating on the wage, right, cheating in working conditions, then go after those who are cheating, right? Right? You wouldn't get rid of a whole program because there are people that are abusing it any more than you would burn down a house because you have spiders. And that I think, that kind of attitude and mindset, I think it has to start with that public education. The U.S. Chamber represents employers in all sectors who many use the H-1B visa. But the U.S. Chamber also partners with College Board and other organizations to invest in K through 12 education. Right? So this is not to say that the U.S. talent is not important, but the H-1Bs are coming to complement the U.S. workforce, not to displace it.
And very quickly, I think it is critical that employers, industries really, let the representatives, groups like the chamber and others, and the administration directly hear these issues. I mean, when the H-1B, the $100,000 was announced in September, it was announced on a Friday, and we thought it was going to apply across the board to every H-1B, and that people that were outside the country, even on a valid H-1B, were not going to be able to get back in unless they paid the $100,000. The administration, which is very mindful of the economy and not doing anything to upend that, I think heard the cry that went out over the weekend of this is not tenable. And so very quickly by Sunday, we were getting guidance that it's not going to apply to people that already have an H-1B. It's only going to be for new H-1Bs. And gradually we heard that it's not going to apply for individuals who can change status or transfer their H-1B while in the United States. It's going to be people outside the United States. So we've seen it limited in a way that I think is much more palatable, hoping that it stays that way. I mean, there's always sort of hey, unless it's in a regulation or something formal, there's a concern that can change. But I think these things have played out in a way that it's much more palatable from a business standpoint for employers. Hopefully we see some of that with the ICE enforcement efforts and understanding. I mean, we've already seen with the Hyundai plant, the administration said, hey, maybe this was done a little too quickly. Some of these South Koreans may have been in a valid visa status, all of that. So there seems to be a catch up, but it's critical for employers to voice these concerns and to get the administration to hear that.
Thank you, Michael. We are just a couple of minutes left in our time. A lot has been covered. There's a lot still that can be covered on this subject. But at this point in time, I'd just like to go around the speakers and give you one last chance for a short closing statement. What would you like to leave our audience with before we end this? And we'll start with Shelby.
I think as in-house counsel, I would advise anyone that's on the call that's in that role, really understanding that in this environment, I feel like my role has really transitioned from being an advisor and a lawyer and to kind of like a little bit of a therapist. And by no means am I licensed to provide any kind of therapeutic help, but just being there with my business to really help them understand what's going on, because I think they're concerned about what's in the headlines and they don't yet know like how to react. And so my really important takeaway out of all this has been as close as I can to be with the business to help them feel supported.
Thank you, Shelby. Michael?
Very quickly, I would just say, be prepared, do an internal audit now, get those guidance in place now, train your folks who are on the front end what to do if ICE shows up or how to deal with H-1B issues or what have you. It's prepare now.
And Patrick?
I'm going to leave with a hopeful message. I actually think that the time now is better than it has been for the last several years to make immigration reform a reality. And the reason is that the temperature has been dialed up so high that elected officials in blue states, red states, they're hearing from their constituents. So make your voices heard, express your concerns, contact your lawyers, your trade associations about how you can organize these efforts. I mean, contact the chamber, we'll guide you. And there's one person working in this administration now that understands the role of immigration in our economy. That's President Trump himself.
Well, with that, I want to thank our very prestigious panel for your time and sharing all this information. I'd like to thank the ABA for giving us the opportunity and the forum to put this out there, and all of you for your time. If you're interested, our third in the series will be held on December 17th it's going to focus on terminations, false claims, and grant programs. So mark your calendars for December 17th. And with that, we are out of time. And thank you very much. And I will remind you, if there's any outstanding questions, please don't hesitate to email them to any of us, and we'll make sure we try and get you an answer. So thank you very much, everyone, for tuning in, and hope to see you on December 17th.